Hi, everyone. Harry here to talk about the New York AG. This is Letitia James's office response to Trump's appeal to the appellate division seeking to set aside the gargantuan civil judgment, $450 million or so, both saying there were legal infirmities overall and that the amount is wrong or excessive. Okay, let's just set the table briefly. This is the one before Justice Engoron. It was finished. The trial was an 11-week bench trial. Bench trial, I note, so it was all the more perplexing that Trump continually hectored and Gorin and tried to say he was biased. Then when the eventual judgment was reached, it was trebled under state law, and we're talking about $450 million. You may remember there then ensued a bit of drama about whether Trump even could post the bond. You can appeal, but you have to post a bond typically for the full amount. The appellate division, which is the appellate court just above Engoron, stepped in and said, you can do it for $175 million. You don't have to post the entire amount. Perhaps that'll be taken as an indication that they are considering diminishing the amount of the award, something appellate courts do with frequency, though typically it's because they find a jury has acted excessively or with prejudice, and this, as I say, was a bench trial. All right, to recap the nature of the charges. So this is the case in which Trump methodically, through a series of different stratagems, including his co-defendants, Alan Weisselberg, top financial person in the Trump organization, and McConney, the person right under him, testified at the criminal trial. Weisselberg, of course, didn't, and Weisselberg was serving a second sentence in Rikers Island. It was for perjury growing out of this case. This is the one in which one of the inflated properties was this apartment that Trump said was 30,000 square feet, even though it was 10,000. And Weisselberg lied when he discussed his own role there and suggested he had known nothing about it when it was clear he had. Okay, but the basic scheme here, the apartment is a particularly pristine example because 30,000 square feet is not 10,000 square feet, but the judge, acting as fact finder, heard of 20-some examples over the course of many years in which the Trump organization inflated the value of property by grotesque amounts. We're talking about, from values of 3, 4, 5, and more. And why did that matter? It enabled the company to get loans, and they desperately needed, at values and rates that were much lower than they should have had to pay. All right, so that I'm just reviewing the facts there. Now let's go to the defense that Trump basically made a trial. There are a number of them, but here's his pitch. Hey, the banks got paid back. No harm, no foul. What is the problem here? And that's really the main argument that he makes again here now on appeal. He made it at the trial itself. The banks got paid back. But it's just based on a basic misunderstanding, maybe a willful one, about the law he was sued under. So this wasn't about a cause of action against by the banks. This is by the Attorney General, and it's by the Attorney General under this very powerful, wide-ranging fraud law, civil fraud law, Section 6312, parentheses 12, that gives the Attorney General jurisdiction to go after all sorts of fraud, and that makes a fraud claim a violation of there's damage to the public fisc, even if you can say, oh, we paid back the banks. So the argument that he launches again in the appellate division is of saying, well, the banks got paid back, so everything's fine, just turns a blind eye to the law that he was found liable under, which is one having to do with fraud. And the theory of the law is it's the public that's injured, although so the banks got paid back, it's true. But if Trump had told the truth and the valuation of the properties had been bona fide, then he would have had to pay much, much more money in order to a much higher rate in order to get the loans. So first, the theory under 6312, the substantive theory, he committed fraud. And the Trump organization committed fraud, and McConney helped, and Weisselberg helped, etc. So that's this law that the AG sued under, 6312, doesn't require a victim, doesn't require reliance. It's about New York business practices, and that people doing business in New York be on the up and up, not lie flagrantly, not have fraud schemes in order to make more money. But that is what Trump did. So the theory of damages here is a disgorgement theory. So it's not about how much the banks lost. In fact, the banks didn't lose. It's rather how much did Trump organization gain? How much money were they able to get by getting loans less than the amount that they should have had to pay? And that is, roughly, that it's a little more complicated than this, but that's the basic theory, a disgorgement theory. And the amount is in the $150 million range, and that is trebled under 6312. So he's looking at $450 million, and that accrues interest. So he's had to post the bond, only $175 million, but the actual amount that they are liable is growing daily because interest is imposed. So he's going to hope that and not exactly as an act of mercy, but what a court of appeal would do in a jury judgment is say, this is too much. It was influenced by prejudice and passion. I don't know if they'll say that about Justice Merchan, who did it here, but the fact that they permitted Trump to go forward on a bond of much less than 50% of what he owes, does suggest that the court might be prepared to reduce the amount. So, I mean, in essence, they have a two-part analysis. Was there fraud under 6312? Was it a proper 6312 suit? Trump's main argument here is just completely beside the point. Oh, the banks didn't lose money, no harm, no foul. But that specifically misstates the law that the AG sued him under. And then, assuming so, the next thing that the appellate division will go to is whether or not the amount should be reduced. And that's a pretty loosey-goosey, does it feel like too much kind of remedy, and they can reduce it. Okay, they are going to hear the case, the appellate division, September 26th. And they take about a month to decide these cases, meaning that, in theory, the decision here could drop roughly the last week in October. So, in other words, in a very eventful time in the political calendar. So if they affirm the judgment and affirm how much he owes, And remember, this is New York State Court. There's a lot of ways in which, if he wins the election, he can undo things or make trouble for the people who have sued him. But a state civil suit that where there's already been a judgment, I don't know. I think that could be pretty hard for him to reverse. But I should say that after the appellate division rules, which might be roughly at the end of October, he could then petition the Court of Appeals, which is the highest court, the Supreme Court in New York. From there, the U.S. Supreme Court, but the claims that he's raising here about New York law and what it means and about prejudice or too much of a remedy seem to me to not really present something that the Supreme Court should think about or decide. In other words, not a federal question. So I don't really see that the Supreme Court is much help for him here. Okay, one other point. Lawyers for Trump were sanctioned as part of this lawsuit. You know, it's part of the everything Trump touches dies, but his lawyers are forced into these ridiculous positions. And they made a representation to the court that said this law doesn't apply about 6312 when the exact opposite already had been decided. So just a flagrant, Alice in Wonderland instance of this is what the law says when it's not what the law says. So Engoron responded by imposing sanctions on them. And it's, the Trump lawyers are always pushed to such crazy submissions. And there are limits here that lawyers have to think about, including potentially their licenses, but certainly you can be sanctioned. So here they were sanctioned. And the final argument that the Trump folks are making is, get rid of those sanctions for no real reason. Try to say it was in good faith, but it's very hard to. I mean, it was patent that because it was in this very case that their argument had been rejected. So the last submission from the New York AG is this is perfectly appropriate sanctions and don't change there. Okay, so the basic arguments was 6312, the fraud law properly applied and doesn't matter. That the banks didn't lose money, and the answer ought to be it was properly applied and it doesn't matter. Then this really big honkin' amount of damages for a disgorgement theory. Might the court reduce that? And then finally the issue of sanctions. So we may see the appellate division decide all this a week or two before the election, which could in fact have its own impact on the dynamic in November. But in any event, this is a case that Trump is very hard pressed, even if he wins the presidency, to undo, and it could be enough money and a price tag to really clobber him. It was considered that this was more cash than he could raise. And we don't know exactly what he's worth, but he always inflates it. $450 million is a goodly portion of his worldly fortune. So this is serious and not one that he can easily undo. And the claims to the Supreme Court of New York are unlikely to fly. His best hope here is a substantial reduction in the amount, and that could happen. So stay tuned for the appellate division, September 26 argument and decision around the end of October. And hopefully you now know the stakes and what he could reasonably hope for and what the AG could reasonably hope for. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.